Welcome back to the Constitutional Clarion. I've recently been doing some work on issues concerning the failure of elections. This has thrown up some intriguing but improbable scenarios. I thought they might be of interest to those of you who are fascinated by the quirky possibilities arising from our constitutions and electoral laws. This video is therefore about what happens if too many or too few candidates nominate for an election. How, you might well ask, can there be too many people to nominate for an election? In a democracy, shouldn't any qualified person be entitled to stand for Parliament? Yes, but logistical problems can arise if there are too many. The biggest problem is the size of the ballot and the ability to produce ballot papers naming all the candidates within the short period of time between the nomination day and the date for early polling. I was reminded of this when I recently read about the by-election in Canada for the seat of Battle River-Crowfoot, which is to be held on the 18th of August. As you might be aware, at the general election in Canada in April this year, Mark Carney's Liberal Party surprised the pundits by defeating the Conservatives. The Conservative leader, Pierre Poilievre, and apologies if that's not the Canadian pronunciation, anyway, he lost his seat in Ottawa. A member of his party, Damien Curac, then volunteered to resign from his riding in Alberta to let Poilievre run for it in a by-election and therefore return to Parliament. That riding is a particularly safe one, as Curac had won it with 82% of the vote at the April election. So Poilievre's election ought to be a shoo-in. But a group called the Longest Ballot Committee decided to protest by trying to get at least 100 people to run as candidates. This group argues that politicians have a conflict of interest in relation to electoral laws and that those laws should be made by an independent, non-partisan body such as a citizens' assembly. There were obviously plenty of other people who were peeved by what had occurred because they got over 200 candidates to run, with a grand total of 214 candidates altogether running in that by-election. According to the Globe and Mail, one of the protesters, who nominated many of the candidates, said that it perhaps amounted to an imperfect method of trying to change an imperfect system. Previously, the longest ballot paper in Canada had been over 1 metre long, but that was with fewer than half the number of candidates that are actually standing in this by-election. The consequence was that the printing of a ballot paper became impractical. Instead, a write-in ballot is being used, with voters being required to write in the name of the candidate they wish to elect. Apparently, if you can't spell Poilievre, that's okay, as long as you get close enough, as hopefully my pronunciation has been too. Poilievre has apparently argued that the law should be changed to prevent such protests. He contends that there should be unique signatures nominating each candidate, and they should all have different financial agents rather than relying on the one organisation to support them and marshal the necessary nomination signatures. For anyone watching from New South Wales, this may bring a sense of déjà vu. Back in 1999, we had the tablecloth ballot paper for the New South Wales Legislative Council. This was largely the consequence of numerous parties with catchy names being established by the same group of people to harvest preferences and pass them on to a chosen party which might have quite different policies. On that occasion, had 3 or 4 more parties nominated for a box above the line in 1999, it would have been impossible to print big enough ballot papers in time for holding the election on the constitutionally required fixed date. There were simply insufficient printers in Australia to handle a bigger ballot paper and not enough time to get them processed overseas. That problem has since become exacerbated because so much now is done online these days that there are even fewer printing machines in the country that can produce very large ballots in a short period of time. To alleviate that problem, the electoral law was changed in New South Wales so that parties that wanted a box above the line had to register at least a year in advance of the election. This avoided the last-minute crisis of finding that one had more parties than a ballot paper could bear after Parliament had already been dissolved so that nothing could be done about it. Second, the law was amended so that to get registered, a party had to have 750 members who were enrolled voters and who did not overlap with the claimed members of any other registered party. A similar law was later adopted at the Commonwealth level and was challenged in the High Court in the case of Mulholland and the Australian Electoral Commission in 2004. The High Court upheld the validity of the law. It considered that fixing a minimum level of support for parties and the avoidance of abuse by imposing a no overlap rule were consistent with the constitutional concept of direct choice by the people and with representative government. Justice McHugh expressed a concern about the ability of front or decoy parties to mislead voters. He thought that requiring a minimum verifiable level of public support minimised voter confusion and prevented voters from being misled. If the restrictions had been for other purposes, however, such as favouring a particular political party, then the court might well have taken a different view. Another mechanism to deter floods of candidates with little or no public support is the requirement that they provide a deposit with their nomination. In New South Wales, in the lower house, a candidate can be nominated either by a registered political party or by 25 electors who are enrolled in the relevant electoral district that's being contested. They must provide a deposit of $250 or $500 if they're running for the Legislative Council. The deposit is returned if the candidate is elected or receives at least 4% of first preference votes. If the candidate is a member of a group in a Legislative Council election, the deposit is returned if a member of the group is elected or if the group receives at least 4% of first preference votes. At the federal level, the deposit is much higher. It's $2,000. What about too few candidates nominating? What if no one nominates at all? What happens then? While this seems improbable, there is precedent for it. Again, it arose in the context of a protest. In this case, it occurred during colonial times before the establishment of the state of Victoria in Australia. The Port Phillip district, as it was then known, was part of New South Wales, and it was represented from 1843 in the New South Wales Parliament in Sydney. Yet Sydney was so far away and transport in those days so difficult that people living in Melbourne either elected someone who didn't attend those sittings in Sydney, or they were represented by a Sydney-sider who really didn't understand their concerns or provide appropriate representation. Unhappiness with the inadequate system grew. In July 1848, after candidates were publicly nominated to fill the 5 places allocated to the Port Phillip district, one of them took the floor. He complained that it was a farce, and he called upon the electors to reject the fiction of their representation in the New South Wales Legislative Council. He proposed that they should adopt a policy of passive resistance. There was spontaneous agreement and all nominations were withdrawn, causing the election to fail. In this case, the people were able to speak louder and be heard by not electing representatives. The election was, however, rerun in October 1848. This time, some genuine candidates nominated, so the no election campaigners came up with another form of protest: joke candidates. They nominated famous people from the other side of the world, such as the Duke of Wellington, Viscount Palmerston, the then Prime Minister, Lord John Russell, and the former Prime Minister, Sir Robert Peel. According to the press, this was accompanied by outbreaks of laughter, hisses and groans. These were the days before the secret ballot, where nominations and voting happened in public meetings. There was also no requirement that a nominated person actually give consent for their nomination or even know about it. The Duke of Wellington, who had been victorious against Napoleon at the Battle of Waterloo, was soundly defeated in the electoral battle for the city of Melbourne. But the colonial secretary, Earl Grey, whose family today is more famous for its blend of tea, was actually elected to the New South Wales Legislative Council with 74% of the vote, even though he had never visited Australia and was not likely to do so. The reason was that he was the man with the power to establish a new colony in the Port Phillip district with its own parliament and its own representatives. The press in Sydney was not impressed by this form of protest. The Sydney Morning Herald described it as an act of flagitious mockery and argued that the conspirators in this political crime deserved to be whipped. But did it work? Well, yes, it seems to have done so. It certainly got attention. A formal apology was sent to Earl Grey by the people of the Port Phillip district, with an explanation that they had been made to feel like they were governed by aliens, strangers and competitors. They complained about money raised in the Port Phillip district being used to fund public works elsewhere, while their own schools and police were deprived. They asked how they were expected to submit to the continued perpetration of injustice. Earl Grey accepted that they did have a legitimate concern. In 1850, the Westminster Parliament passed an act which separated the Port Phillip district from New South Wales and named it Victoria, after the Queen. It was granted its own parliament. As for Earl Grey, he became disqualified from the New South Wales Parliament for having failed to attend, and his seat was vacated. What do the laws say today about such matters? In a New South Wales Legislative Assembly election, if only one candidate nominates for an electoral district, then Section 92(1) of the Electoral Act 2017 says that the candidate is to be declared as duly elected without any vote being held. If no one nominates at all, then the election for that electoral district has failed. Section 76 of the Electoral Act provides for the Speaker, or in some cases the Governor, to issue a writ for a fresh election in that electoral district, as indeed had occurred back in 1848. According to Section 30 of the Constitution Act 1902, the Legislative Assembly is allowed to sit and deal with business even though up to 5 election writs have not yet been returned or the electors in any electoral district have failed to elect a member. It's more complicated, however, for a Legislative Council election because the entire state is one electorate and 21 members are chosen at each periodic election by way of proportional representation. What if fewer than 21 people nominate? According to Sections 92 and 220 of the Electoral Act, all the candidates who have been nominated are then declared duly elected without any vote being required. But what about the vacancies that are still left over? Section 22(d) of the Constitution Act 1902 provides that whenever a vacancy occurs in the seat of a member of the Legislative Council after a member's term has expired, but the vacancy is not filled because insufficient members are elected at the periodic council election, then the Governor shall convene a joint sitting of the Houses to fill any such vacant seats. Ordinarily, when a joint sitting is held to fill a casual vacancy in the House, the person chosen is required to come from the same political party that had endorsed the election of the outgoing member whose seat is being filled. But if it's a case of not enough people nominating at an election to fill all the seats, Section 22(d) of the Constitution Act says that this requirement does not apply. It would be a matter for the joint sitting to decide by majority who gets the vacant seats. There's no real possibility of having too few candidates these days to fill Legislative Council seats. Even if political parties, in acts of spectacular incompetence, were to fail to submit their nominations in time, or if they decided to boycott elections as a protest, there would still always be enough candidates from minor parties or independents to fill the spots. The more likely scenario is too many candidates with resultant confusion for voters and an inability to print large enough ballot papers in time for the election. These are the things that give electoral officials nightmares at night. Thank you for watching the Constitutional Clarion. I hope you found this interesting, and as always, I look forward to seeing you again next time. Goodbye.